This is Skyline Terrace Housing versus Robert West and others. On behalf of Skyline.
Hello.
Good afternoon, Sellers.
Yes, Carissa Sellers.
Thank you. And do I have anyone here on behalf of Robert West?
I don't think so.
Don't see
I did
anyone.
not have anyone appear.
All right. Ms. Sellers, I'll pull up return for the defendant, but why don't you give me the information about why this case was filed?
The short bit is for starting a second fire for tampering with lithium batteries on property multiple times. We first noticed there was a very large fire with many people, 9 people displaced from tampering with a lithium battery. And we said at that point, you need to exit. We gave the 10-day notice to cure and then a notice to vacate, lease violation.
Okay,
And
the
then we
notice to
found,
cure?
I know, just
I
to
appreciate
make
it.
sure
That's lovely. I'm just sort of thinking that one through. The statute's only about payment, so
Right.
you know.
We
Okay,
just
all right, but y'all
wanna
are.
make
I hear
sure-
it. You're giving him really opportunities here.
But this is back in July because we were giving him the opportunity to find another apartment. And then we did another inspection last month and we found 7 more batteries. So we are going forward with eviction.
Is this I mean, is this sort of like you know, you hear about like on airplanes where the battery just burst into flames? Is it like that?
It was an explosion. Like we have it on camera and it just the battery exploded and it was scary. I mean, and it
fearful of all of my
fire.
clerks in the department. Like right about that, I'm just like, JC, I'm worried. Like,
yeah, no, it's definitely scary. We've had 2 now, and both of them were like bombs going off. So the apartment was ruined. It's still not livable.
okay.
So,
And you've given me all of the information. I see that very specific warning. Yeah, here's the notices, TCD. Okay. Okay, I understand more of your housing situation. That explains a little bit more about why there was a lot of deference provided, which is lovely. 2 thumbs up, right? I can, not as I would typically hear from a different situation though, but that makes more sense now. Okay.
Right.
Yeah. All right. Other than possession and cost of court, is there any financial amount here? This just seems
No, we're not asking for any money, just possession.
Thank you. Did provide us with a copy of the notice to vacate. I see notice of lease violations. There's actually multiple here going back through August. Okay. Yeah, our new petition looks a whole lot different because it now incorporates all these additional requirements from the statute. But we did get back the return. I'll just share that now. Return was left on the door and mailed, which is appropriate for alternate service. Here is that for Robert West, cause 2652. It was affected by Deputy Hobbs and returned to the court. Okay. Judgment for the plaintiff with possession and cost of court. I do need to set an appeal bond for this, Ms. Sellers. Because there is an allegation of potentially a dangerous situation, how much had the rent been or under the lease?
So his rent, he has a voucher and his rent is $280 a month. We actually also offered $1,000 cash to avoid all this. So he seems to have money. So if we could make it like his leased rent is $1,519.
Okay.
So even just 1 month, right? 1 month is $1,519. That would be.
I would actually, because of the circumstance, right? And this is because of what has gone on and the 2 priors, and you have a good documented history that you provided as part of your filing with the court, and we take that all as true. Given what I'm hearing, I would not have any issue making the appeal bond be equal to rent. I was actually going to do a different way, and I was going to, go all the way back from the beginning for the violations, which would have made it a little bit higher. So your suggestion is actually a little bit lower because I was going to take the number of 280 and go all the way back through August. So August, September, October, November, December, and January. Maybe he was going to get 7 at that. Your number is actually a little bit less. So I'm okay with that. We'll put the appeal bond at $1,519. And I think that is absolutely reasonable and sufficient to secure the premises for parties. Also, I don't know that y'all have probably gone through training too, but I'll highlight the new statute requires payment into the registry for all cases to avoid a writ of possession, no longer just non-payment matters.
Oh, okay.
So for example, in this case, if the defendant wanted to appeal, he may qualify for the affidavit of ability due to the other circumstances, right? But in order to remain in the unit until or unless a court hears it, he would have to pay $280, his government portion, ongoing as it comes due. Otherwise, y'all could get a writ of possession.
Okay.
And that is a big change, because that was only true for non-payment matters, but now it is all cases. And in a situation in which there's never been a writ established, let's say I've got, like, boyfriend and girlfriend living together, and now there's a domestic, the court must put in a minimum of $250. So there can be no amount due that is less than $250. We can make it higher, but it cannot be lower. And that's true regardless of what the defendant's actual portion is.
Okay.
Yeah, I know it's a very
Yeah.
that's a sticky one too. So like we've been, all right, every single one has to have some amount to pay it. At a minimum, it must be $250.
Okay. Interesting. I hadn't heard that one.
All right. Well, Ms. Sellers, if you have no other matters, then it is judgment for the plaintiff, and you're all free to go now.
All right. Thank you very much.
Thank you. Have a nice day.
You too.
Why was this case filed?
This is for non-payment of rent, Your Honor.
How much is the rent?
The rent is $1,400.
Any subsidy?
No, Your Honor.
All right. What months are sought?
Ma'am,
What months are unpaid?
I'm sorry. The months of November, December, January, and February prorated.
Okay. Was this a
And
CARES property?
No, ma'am.
It was a notice to vacate or notice to pay or vacate provided?
This was a notice to vacate.
Had there been a previous chance for him to pay?
I don't know. And I went back through the ledger, and I don't see where he was late previously.
Oh, that's going to be a fatal flaw then, Ms. Hedrick.
I had a feeling.
I know. We're in that first month of this kind of catching up, and that's a weird one, right? I absolutely understand. And then also, now I've got my calendar over here calculating that the day of the move out isn't right. I know that's a fun one. Ms. Hedrick, I give you an option. Then if you look at it, you know that they needed to get, because I mean, if it hasn't been previously, it's going to be it would probably be judgment for defendant. I can do it judgment for defendant, or you can non-suit because you're still technically within your case in chief.
Let's do non-suit.
Okay, we'll do that. Mr. Durham, I'll give you a little bit of information.
Yes, ma'am.
Ms. Hedrick has dismissed the case today. She's not
Okay.
dismissing it because she doesn't say there's an underlying fact about non-payment, but the state law changed. Effective January 1st, this is a big change in the law for all parties. A landlord is now required within a rental period, if you've not been late before, they must give you an opportunity to pay up or move out. This only happens once in the rental period. So if it's already been given to you, then they can just give you the notice to vacate. What Ms. Hedrick is saying is that per what she's looked at, there had not been an opportunity given to you to pay before being told to vacate. And because they didn't give you that now required by law notice, she's non-suiting the case, which means that if you still are in a situation where you're behind on the rent, you may now go through that process. Your landlord might give you a new type of notice now.
Okay.
But today, essentially their case has been dismissed. They're non-suiting.
So for the balance that I owe, when I spoke yesterday to the community, the Gables customer care, as of, well, I spoke to them on the 27th, and they said I could pay on the 31st, which was a Saturday. I tried calling on Saturday and the office was closed. I was at I got a new job. The reason I didn't pay is because I lost my job. And but I finally have a new job. And I called them on the 2nd yesterday. The original amount was approximately $5,200 for those months. And then yesterday they said it's actually $6,700 because of the month of February. So the lady asked me, the lady I spoke with said that I can speak with you about possibly setting up a payment plan with them to pay.
Mr. Durham, give Ms. Hedrick a call outside of court. I got to move to the next case because I don't do the payment plan. But yes, you certainly can do that, Mr. Durham. You're all free to go now. Case has been dismissed. Okay. Contact your landlord. All right.
Okay.
Thank you. Ms.
Thank
Hedrick,
you.
thank you very, very much. Well, do you have other matters today, Ms. Hedrick?
Not today. Let me
All
ask you
right.
one question, though.
Absolutely.
This suit, the delinquency occurred November and December. The suit was filed in January, so I am under the new rules.
Still stuck under it. And I love that question, Ms. Cedric, because I just last week was at my mandatory first 20 hours of CLE, and this is the sticking point. So y'all should be, we're trying to be consistent. All the JP should be clear. If it's filed in 26, you got to follow the rules, even if the notice to vacate was in 25, because it's the current statute we're under. But that's a great question, Ms. Cedric. Yeah.
Okay. Thank you, Your Honor.
Thank you. Y'all have a good afternoon. All parties to
You
that are
too.
excused. Thank you.
Okay, bye-bye.
All right. Then we will be with 2648. That is right. Bridge at Turtle Creek versus Demetrius Hosea Morris Jr. Who do I have on behalf of the bridge at?
Hi, Barbara. I'm the assistant manager at Bridge at Turtle Creek.
I'm sorry, tell me your name one more time.
Amaya Barbarella.
Good afternoon. Thank you for being with us, Barbarella. All right, and do I have someone here on behalf of defendant Demetrius Hosea Morris Jr.? I see someone named Demetrius Morris. Mr. Morris, I see you waving at me. You're on mute, sir. Oh, you got it.
Yeah, it just popped up from the mute.
It automatically happens. We typically put everyone to mute when we get started. Otherwise, you know, we hear people's dogs and sounds, and we're not trying to have that. All right, good afternoon to you both. All right,
Good afternoon.
why was this case filed, ma'am?
Can I say that again? I'm sorry, I couldn't hear you.
What was the reason for the eviction to be filed?
Oh, okay. It was a non-payment of rent.
Non-payment.
yeah.
How much is the monthly rent?
$13.50?
Is there any subsidy?
No, ma'am.
What months haven't been paid?
December 2025, January 2026, and now February.
Okay. Is this a CARES Act property?
Yes, ma'am.
Had rent previously been late?
Yes. We filed for just January, but he had been in December.
Okay. In the notice to vacate, did you give him a notice just to vacate, or was it a notice to pay or vacate?
A notice to vacate. It was our understanding that if he had been late before, but I did hear, for the previous case. So for January 2026, he needs to be issued a notice to pay or vacate. So even though he has already been late before.
So the statute now is this, right? And I'm not giving any legal advice because Ms. Barbarella, you are represented by other people. I'll give you what we were taught and what the statute reads for us. So this is the way the court has interpreted it. I don't think I'm doing it wrong. This is it, okay? So the new statute that began January 1st applies even for leases that started in 25, right? So if they're in their original 12-month term, and let's assume it's a normal 12-month lease, if in that 12 months you have never given them the chance to pay or vacate when they're late, you must do it at least once. So if he's been late before, but you only gave him a notice to vacate, that doesn't qualify. You have to have at least once before a notice to pay or vacate. So like, for example, if y'all gave it to him here, if the time you gave the notice to vacate in this particular instance, if the notice to vacate said pay or vacate, you'd be covered in the case we go forward right now. If it only said notice to vacate, then you fail under the statute because you must give him a pay or vacate at least once.
Okay.
But let's say in July, hypothetically, someone had been late and you told them to pay or vacate and they paid. And then in September, they were late again. Now you only need to give them a notice to vacate.
Okay.
And if you had held on to that and just filed now, you would still be covered because you were in that. So that would be the question here. If you have given a notice to pay or vacate previously, this notice to vacate would be valid. But if it's all you gave, then yeah, it's going to be your choice of either non-suited or judgment for defendant.
Okay, we did give him a late payment notice to pay or vacate in December.
Okay, so the one y'all gave in December says either pay or vacate.
I would say,
Let's take a look. Is that the one y'all submitted to us?
I was not submitted with the suit, so it needs to be submitted with the suit.
No, it just, right, if that's the notice to vacate that satisfies the statute, let's see it. Y'all filed one at the time of the petition. This one is January 7th. This one is just a notice to vacate.
Mhm.
And you're saying y'all had given it one previously?
In December 2025.
And that one was a pay or vacate?
That was the first time he was late, so yes.
Okay. And that one right now, your testimony is that you gave him a pay or vacate notice
Yes.
in December.
Yes. That one was a 30-day one. Good, but not this one is the a 3-day one.
What was the date of the one in December?
Should have been. Yeah, it would have been the 5th.
December 5th. And he did not pay or vacate, so when January happened, y'all gave him a new one.
We filed on the 14th. We issued the notice to vacate on the 7th and we filed on the 14th.
I see that. Okay. Thank the legislature for this. Oh, God. So you gave it to him on the 7th. 1, 2. So here's where the fun is, y'all. Looking at the calendar. Ready? This is the fun. So y'all might listen along and pay attention. You gave him a notice on January 7th. If you gave him a 3-day notice, 3 days would have put you on Saturday the 10th. He gets until Monday the 12th. Right? I know that's because if it lands now on a weekend, a holiday, state or federal, they get it till the next business day.
Okay.
Okay, so your 3-day notice effectively gave him 5 days. But what you're saying here is that as of the end of the 12th, he has not moved out.
Yes.
He is still in possession. All right. All right. All right then. Mr. Morris, good afternoon. You've been very
Good afternoon.
patient. We've kind of gone
Yes,
through
ma'am.
everything, but I've got a good timeline now from the landlord, and here's what she's told me, okay? She said that you were late on your rent in December, and when you were late in December, they gave you a notice. They gave you 30 days to pay or vacate. That 30 days passed, and in the midst of that 30 days, you also missed January's rent. So on January, they gave you a final notice to vacate that said, you still owe for December, you haven't paid that up, you now owe January, you gotta go now. Is that accurate, sir?
Yes, ma'am.
All right, I appreciate that. Mr. Morris, with that information, landlord wins their case today. I always want to give you a chance. I'm happy to hear any answer, hear information, certainly answer any questions that you've got. I'm gonna do some calculations so I can give you an exact amount of money for the order, okay, sir?
Yes, ma'am.
All right, so we got 1350 is going to be December and January. That's easy. So that's 2,700. For the month of February, it's 28 days for 3. I get 144. So judgment for the plaintiff, $2,844 for back rent. To that, we'll add the cost of court. Either party can appeal. I will keep the appeal bond to 1 month of rent and make that $1,350. Mr. Morris, you have 5 days beginning tomorrow to appeal or move out. If you do nothing at all, on day 6, the landlord legally can come with a writ of possession and have you removed. They have up to 60 days to do that. So you may talk to your landlord if you're interested in kind of what they're thinking about that, but that is the soonest they can take any action. All right, sir. Can I answer any questions?
No, ma'am, that's good. Thank you.
All right, we're going to email you that. We'll also mail it to you the old-fashioned way. Thank you. All right, you're all excused. Have a better afternoon, sir. And Ms. Barbarella, thank you. Very patient, good information. But that's
Thank you for your
well,
help.
and that's a good one, y'all. So if you've done one before, we're going to have to, that is going to be a necessary part of question. We've also updated our petition. So for our landlords that file a lot, maybe update your form from our newest petition on our website. It now incorporates that previous notice to pay or vacate stuff. So when you have a default, your petition can include it. Otherwise, I'm gonna have to make you go through that whole little laundry list. FYI, we have put it into the petition. The training centers put that out. So you'll probably get that across the state from any of the justice courts that you file in, an updated petition that incorporates that new statutory requirement. Extra information for y'all. All right, next is going to be 2650. Also, Bridget Turtle Creek versus Judy Ann Autor. I'm Ms.
Yes.
Barbarella here on behalf of Bridget Turtle Creek. Do I have someone on behalf of Judy Autor?
Yes, ma'am. I'm Judy Hattori.
Good night. Good afternoon, Ms.
Good
Autor.
afternoon.
Thank you. Ooh, I like your last name. That's very pretty. All right. Tell me about this case, ma'am.
We actually would like to dismiss this case. She's paid in full. She's good to go.
Non-suit. Happy to do it. Have a great afternoon. Ms.
Okay.
Autor,
I have
you're
one-
all excused.
I have one question, ma'am.
Absolutely. For me or for the
For
landlord?
you, I guess. Does this
Certainly.
affect my credit history for rent to apply in the future?
I don't know that it would have an impact on your credit. What they've done is they've filed, there's a public record now that a filing was made against you, but that same record will reflect that it was dismissed by the plaintiff. Which means that there's no final judgment being entered against you. And I would say maybe talk to your landlord about how they view those things, but it is not the same as if you had been evicted today and had a judgment rendered against you. They are non-suiting the case up front, and we're going to mark it that way, non-suited by plaintiff.
Okay, so it doesn't come up in the history at all. Credit.
I can't answer that. There's different ways that landlords look at things. What I'll say is that if I was to, from a legal standpoint, looked at it, I would see that you had a filing, but that filing was dismissed. I might think many things at that point, but you would not have been found, you would not have had a judgment taken against you. And certainly many people would say that's better.
That's good. Yes, yes, ma'am. Thank you.
All right. Well, thank you, Ms. Altori. I'm happy to answer that. If there's nothing else, you're all excused.
We are seeking eviction because of non-payment of rent.
Okay.
A notice to pay or vacate was delivered on January 8th, 2026.
And how long was the defendant provided?
3 days.
All right. And did they pay or vacate?
No, ma'am.
How much is the monthly rent?
$16.99?
Any subsidy?
No.
What months are being sought?
It's for December, January, and now February.
Okay. And was this a CARES property?
No.
Mhm. You filed on the 14th, so that's sufficient for 3 days given on the 8th. Okay. Good afternoon, Ms. Wingo. Thank you for being with us. Ms. Wingo, you're on mute, so you'll need to unmute yourself so I can hear you again. Ms. Wingo, on your phone, you might
Of
press
course,
star.
thank
Oh, there you go. Can you hear me all right now?
Perfect. I
Okay.
can, yes, Your Honor.
Fantastic. Ms. Wingo, thank you for being with us. Ms. Guillen is here from the landlord. She says this case is about a financial situation. So my first question is it correct that the flat monthly rent is $1,699?
That is the flat rent, correct?
Okay, that's all they get to ask for. So I don't care about all the other stuff that they might charge for, pool
No, that's
fees or
fine.
whatever. All right. Ms. Wingo, is it also correct that December, January, and February have not been paid?
That's correct, yes.
Okay. With that information, then, Ms. Wingo, the landlord wins their case today, but what questions do you have? What information can I give you?
I think that should be it. I know the initial case was dismissed. Does that affect timing or anything, I guess, on that was dismissed and we had to refile back again?
No, I mean, for today, for their purpose of their filing, they've established all the elements they need to win the case. So it may be that they have
Perfect,
filed
yes.
before
So
and
it's
just-
still the 5 days.
That's all that. That's a good
Okay.
question. Sometimes we do have multiple things that get filed for these, but no, this one is on its own, and it's entirely in this particular case. They've checked the boxes they need to make to a verdict. Okay. Where's
Of
my map?
course. Thank you so much.
I'm sorry.
No, just thank you.
Oh,
That's
okay.
it.
I'm not trying to check over you. We're great. All right. I did my calculations for February. I got $182 for the 3 days. And when I add 182 to the 1699 and 1699 for 2 months, that's 3398 plus 182. I think my calculator is just wanting to be funny with me. 3398 plus 182. Did y'all get 3580? No. I'm telling y'all, I have a calculator that does some weird things with it. Yeah, 3580. So my own math works. Okay, judgment for the plaintiff, $3,580 plus cost of court. Either party can appeal. I'll keep that to 1 month of rent. So the appeal bond will also be $16.99. Ms. Wingo, we're gonna send you a copy of the order. We send it to you, we send it to the landlord. We also mail it old-fashioned style. If you don't take any actions 5 days from now, on day 6, the landlord can receive the writ of possession and go ahead and have you removed if you've not already done so. You can talk to the landlord in between now and then. If you do appeal and you pay the rent to the court, then the writ of possession cannot issue unless or until you fail to pay the rent. Okay?
Thank
Are
you
any
so much.
questions at all?
No, Your Honor, thank you.
All right. Ms. Wingo, thank you very much for coming. Good luck to you. Ms. Guillen, thank you. If you have no other matters, you're all excused as well.
Much.
Thank you. And I made it. JC, I'm throwing this stupid hybrid accounting calculator away. I don't know. We're gonna use the Windows calculator and just do that. All right, next will be 2657. This is Bainbridge Villas versus Michelle Cardona, Nicholas Matias Detrick II, Zachary Caleb De La Cruz, and others. On behalf of Bainbridge,
Nationwide.
good afternoon.
Good afternoon.
I have someone here. We'll go one by one. Do we have someone first on behalf of Michelle Cardona? How about anyone here on behalf of Nicholas Detrick II?
Yes, it's me, Your Honor.
Good afternoon, Mr. Detrick.
Good
And is
afternoon.
there anyone here on behalf of Zachary De La Cruz?
It's just me for all parties.
All right, well, thank you. I appreciate that. Mr. Detrick, you're doing a thing for everyone. I'm sure they, well, thank you. All right, then. Ms. Garkos, why don't you tell me why this case was filed?
This is failure to pay rent. Rent is $15.46 a month. They owe $866.27 for November, the full amount for December and January, and $165.64 for the prorate of February, for a total of $4,123.91 and back rent through today. A 3-day notice to vacate was given on December 9th, and it was personally delivered to Miss Lopez. There's also a notice given on November 11th. We're seeking back rent, court costs, and possession.
Was the one on the 11th a pay or vacate?
It gives them the unpaid sums. If you wanted to look at it.
Let's see. Let's see. Let's see what their actual language was. Because that's the statutory intent, right? All right, we got a notice to vacate. Let's see if they included both. They may have only done the one. So this is the one dated the 9th, and this one is just notice to vacate, flat out. So that's a notice to vacate. The previous one,
It's the same language on the top.
yeah. Ms. Carcos, I would say this doesn't qualify then, because these are just vacates and not an option to pay up. And it does have to be clear that it's one of the, that it's, you have an option.
Okay.
All right. You're still in your case in chief. We can make it judgment for the defendant with the bond. You can non-suit, your choice.
Just do plaintiff take nothing.
Okay. Judge for the defendant, insufficient evidence. And that's really because it's a lack of the type of service. Kind of your choice on that one. I'll put the appeal bond equal to 1 month of rent, $15.46.
Okay.
All right. Mr. Detrick, I'll give you a bit of information.
Yes, ma'am.
If you've been listening along to the docket, you may have already heard this take place with the case that was earlier. January 1st, Texas Property Code had some big changes to it, and it did update specifically how eviction requirements are. And so there is now an opportunity within a certain leasing cycle for a tenant to get a chance just once to pay or vacate. After that's been squandered or been used, and that's the wrong way to put it, if that's already happened, then the landlord can only say, okay, now you got to go. Here, what Ms. Carcos is looking for, it doesn't appear that the landlord, and this is not a fault with the landlord. A lot of landlords are, oh, that's right. There was this sort of switch over in language, right? If you've been doing something for a decade, I don't have any, I'm not surprised. But what she's saying is that because they've not been able to prove their case to date, you're winning. It is actually a judgment on your behalf, and both you and the landlord can appeal my decision, and the appeal bond would be $15.46. So, Mr. Detrick, the landlord can appeal my decision. They can give you the correct type of notice to vacate, they can do both. They can do nothing as well. Okay, sir?
Sure.
All right, any questions for me?
No, ma'am. Thank you so much.
Then you are all excused. Thank you very much. Ms. Clarkos, thank you as well. Any other matters?
Nope, that's my only one today.
All right, well, go forth and enjoy. Get out of here.
Thank you. You guys have a good day.
Thank you, you as well.
Bye-bye.
Right. 2636. This is Southwest Trails versus Anisa Jackson. Do I have someone here on behalf of Southwest Trails? Anyone?
Yes, Alexandra Garcia, property manager.
Good afternoon, Ms. Garcia. Thank you. And do I have someone here for, I just lost it. Anisa, oh, I see, it's Anisa Jackson. Is that the same person? Are you here, Ms. Jackson, on behalf of 2636, representing yourself?
Yes, ma'am.
Good afternoon. Thank you. All right, Ms. Garcia, tell me why this case was filed.
For non-payment of rent.
How much is the monthly rent?
The monthly rent is 1,366.
Any subsidy?
No.
All right, what months are unpaid?
October, November, December, January, and well, now February.
All right, is this a CARES property?
Yes.
Was a notice to pay or vacate provided?
Yes.
When was that?
We sent out, that one was, well, we sent out a 10-day notice first, then a 30-day, and the 3-day was sent December 2nd, and that one is a pay or vacate.
Okay, so you sent a pay or vacate notice. What day was the pay or vacate?
It was December 2nd, 2025.
Okay. How long was she given on that notice?
She was given 3 days.
3 days. All right. Good afternoon, Ms. Jackson.
Good afternoon.
Thank you for being with us. Ms. Garcia is here representing the landlord Southwest, and she said this case is a financial situation, just as I've heard with lots of others today. So my first question is the flat, just basic flat monthly rent, is that $1,366?
Yes, Your Honor.
Okay. And then is it correct that rent remains unpaid from October?
Yes, ma'am.
Okay. And then Ms. Garcia says that they've given you some previous notices, but the most recent notice, and more importantly for me, a notice to pay or vacate was provided on December 2nd.
I believe so.
Okay. Ms. Jackson, if that's all correct, then the landlord would meet their burden today for one of these types of cases, but do you have any questions? Is there any information the court could give you?
No, you've been very informative with previous cases, so I've been
Okay.
listening.
I try. I don't find that it's obvious, right? Sometimes I find that emotions get in the way and you can also sort of mishear. So it is repetitive, but I want people to be very clear. What is the timeline for it? All right, well, good, then, Ms. Jackson. Let me do some math for you and I'll use a better calculator.
Okay,
All right.
thank you.
So October, November, December, January. We got 4 at the full rate. And then for February, it's 28 days. So I'm getting $48. The 3 days is $146. So for the 4 months at the full amount, $54.64 plus $146. Judgment for the plaintiff, $5,610 in back rent. Either party can appeal. Because it has been since October, I will put the appeal bond at twice the rent, and so that'll be $27.32. And all the same standard conditions and information apply. Jackson, if you're interested in appealing, you certainly have that option. You have 5 days to do so. If you can't afford the bond, you might qualify for an affidavit of inability. In order to remain in place while the case is pending appeal, you would have to pay the rent of $13.66. If you're interested, we would give you a specific time and date for that to take place. All right?
Okay.
All right, if there's no questions, then all parties are excused.
Okay, thank you very much.
Thank you. Very best of luck to you, ma'am.
Thank you.
And Ms. Garcia, if you have no other matters, you're all free to go as well.
Thank you.
We're just needing possession of the unit and back rent. I have a portion for November of 110, December full rent. His monthly rent is $1,200, by the way.
100.
And then January for 1,200.
Okay, how much does he still owe from November?
For November, $110.
That was 110 November, and then all December through now. Was there any subsidy on his?
No,
Okay, is this a CARES property?
it's not.
Was there a notice to pay or vacate?
Yes, it was issued January the 6th of this year.
All right, and how long did he get?
It's a 7-day notice.
Oh, okay. And how did y'all deliver the notice?
It was posted inside of his door and also mailed.
Okay. Now was it a conspicuous place inside?
No, just posted inside the.
Well, that's the new statutory authority. And so we had some discussions like, what do you do when the person is very messy and they've got stuff everywhere? How do you make that conspicuous? And
Yeah. No. We actually tape it. We tape it inside of his.
That's someone said we're gonna put it right on the mirror above the where they use it, like right here. You can't miss it over your kitchen sink. And I was like, you know,
They don't miss it. Yeah, no. Right in the back of the door.
Inside the unit. We did receive back the return. That was done via Rule 510. Alternate service was affected to the defendant. Here is the return. This one is for 26554 for Gabino Prudencio. Deputy Hobbs did affect that, attached it, mailed it, brought back, returned to the court. So defendant did receive service. Okay. And military affidavit, that hasn't changed. Still gotta have some of those. Let's see, it might be in your eviction packet. We do need an SCRA affidavit. Well, JC, do you see it? Am I missing it?
The military.
Yeah, I don't see that so
I
far.
don't either.
That's great, but if you can submit it by end of the day, we'll take that in. Right, that's what we're needing. We need the SCRA. I don't have anything about a military status.
I have it here.
Oh, awesome. Yeah, you just take a photo or scan it in and get it over to us. We'll be good. We'll take a condition.
Okay.
You're making that offer of proof. I see that. Oh. Yeah. Absolutely right. Ms. Green? Good job. I checked everything. Your numbers are right. Timeline was right. Looks all good. All right. Just need the SCRA and we will be all set. It would be a judgment for the plaintiff today. Let me do the math. So December through, just a little bit for numbers, just December, January, and then February. Okay. So 1,200 divided by 28 times 3. What just happened? It's $42 a day for 3 days. I got 128 for February plus 110 left over from November plus 2,400 for December and January. Judgment for the plaintiff, $2,638 plus cost of court. On appeal, I'll put that at $1,200. Ms. Green, thank you. Any others?
No, that's all I have today.
I really appreciate your patience with us then. Have a nice afternoon.
You too. Bye-bye.